And we're live. Hi, this is Sana Chaudhry, the Chief Yeti at YetiZen. And I'm here today for a very exciting YetiZen Speaks online talk about IP issues that can make or break your game studio. And here with me for this talk is James Gatto from Shepard Mullen, who is the co-leader of social media and games at Shepard Mullen. Hey, James, how are you?
Great. How are you doing today, Sana?
I'm doing wonderful. So you have an exciting presentation planned for us.
I am looking forward to doing this with you guys.
Awesome, cool. So let's get right to it.
All right. I just did a screen share. Are you seeing my presentation there?
Yes, we are. All
Okay,
right,
great.
take us away.
All right. So today we're going to talk about some of the key issues that can make or break your studio from an IP perspective. At a high level, the IP protection process is pretty simple. There's 4 steps we're going to cover today. The first is own it. The second is identify it. The third is protect it. And the fourth is repeat. Okay, before we get started, let me ask you a question. Who invented Facebook? I'm sure many of you are thinking Mark Zuckerberg. But for those of you who have seen the movie or actually read the legal papers and understand the backstory, you know the Winklevoss brothers really came up with the core idea first, and Mark took it and extended it, and we'll kind of leave it at that for now. What could have been done differently? Had they protected their IP, it could have been a very different result. So to bring this more home to you in your context, let me ask you this. Once you put out a fabulous game, what protects people? What protects you from others copying your great idea?
Getting results as fast as possible.
Is IP protection. Yeah, move as fast as possible, but no matter how fast you move, people are going to copy you. The only way you can really prevent that from a legal perspective is to effectively ensure the maximum IP protection that you can obtain for your game. So we're going to take a look at what that means. First of all, you have to start with owning your IP. Many times when I have this conversation, people say, well, of course I own the IP. It's my idea. I built it, or I paid someone to develop it for me. Of course I own it. Well, that's not necessarily the case in all situations. We're to look at patents and copyrights. With patents, the way the law works is that absent an agreement or some other law to the contrary, whoever invents something that's patentable owns the patent. Now, you can assign it to a company, but if you don't get the assignment, the ownership resides with the individuals. And we'll see where that can be a problem in a second. With copyrights, the author of the work, that is the person who created it, so either wrote the code, designed the graphics, whatever the copyrightable work is, the author, absent an agreement or law to the contrary, is going to be the owner. We'll look at that as well. So let's take the situation of founders. So let's say you and one of your buddies decide you're gonna start a great game studio. You sit around over beers, come up with a great idea for a game, come up with some great art. You work on it together, and you file a patent, and you do all the right things, and you protect it before you form a company. And when you kind of get down to brass tacks, your kind of co-founder says, I really don't want to spend the time and effort to do this. So where are you? Well, now you have a patent that's co-owned by someone. And if it hasn't been assigned to the company, that can present a problem for you, particularly if you're not on good terms anymore. And that is a scenario we often see. Many times founders will actually file a patent before they start a company. And when we do the due diligence for investors or in other situations, we see the patent hasn't yet been assigned to the company. That can present issues because you want the company, obviously, to own all of its IP. Another issue that can arise is the concept of work for hire. Now, many of you have probably heard this concept, and I'm betting most of you don't fully understand it because many lawyers don't understand it. If you come up with an idea and you want someone to go write some code for you and you pay them, do you own it? Not necessarily. Work for hire may apply, but it only applies to copyrights. It doesn't apply to patents. So the first problem is if you rely on work for hire and something patentable comes out, let's say you come up with an idea and the developer in developing it comes up with something that's an enhancement or improvement to your idea, and you're like, yeah, that's really cool, let's put it in my game. Absent an agreement, you don't own it. And just because you paid for it, it doesn't necessarily mean you own it. And from a patent perspective, work for hire doesn't even apply. What it does apply to is copyrights. So with respect to the code that's being written or any graphics that are being generated or anything that's copyrightable, it may apply. But if you look at the law, and there's cases on this, copyright under work for hire, copyright protection, the work for hire doctrine only applies to copyright and it doesn't apply to computer code. It only applies to certain categories of copyrightable material. So the bottom line is, even if you pay someone for something, if you don't have the express assignment of the rights to you, you don't necessarily own your code. So don't just rely on work for hire. Make sure that there's a written agreement with the developer that assigns all intellectual property, including patent and copyrights, and that will put you in a much better position.
Now, can this be a part of the work for hire agreement with the developer, or does this have to be a separate agreement?
Yeah, no, it can absolutely be part of in fact, it should be part of the main agreement. So you're going to have your development agreement saying what they're going to develop, the timeline, and everything else you're going to put in with respect to the development. Mm-hmm. And in that agreement, you want to address IP ownership, and you want to make sure you own it all to the maximum extent possible. And you want to expressly state that there's an assignment from the developer to you of patents, copyrights, and other intellectual property for what you've disclosed to them and any enhancements that are developed during that process. So if they come up with some ideas like, hey, this is a good idea, you say, yeah, let's incorporate it. Again, because they're either the author or the inventor of that idea, absent an agreement, you're not going to own it. Mm-hmm. So you want to make sure that you have that language to protect you.
Got it.
And then lastly, with publishers, this is another area where, while it may not be effectively an assignment to publishers, there's a number of agreements that we see when people come to us, and there's problems if you haven't really thought through certain things, particularly with respect to the rights you grant to the publisher. If you're giving exclusivity, whether it's geographic or a right of first refusal for subsequent versions, sequels, etc. If there's territorial rights, if you give a publisher an exclusive there, absent certain protections, if they don't actually exercise that right and you don't have the right to take it back from them, you're basically blocked out in certain jurisdictions. And lastly, for adaptation, so whether it's we've seen situations where people will give an exclusive for different platforms. So maybe you'll give an exclusive for someone to do a game based on a movie, or a game on a VR platform versus a mobile platform. There can be different forms of exclusivity based on platforms. And again, if you don't have the right provisions to claw back those rights or require certain minimum production or certain other types of things, it's tantamount to kind of giving away that aspect of what you've granted exclusivity to, because you can't even pursue it. Okay. The next area is identifying your IP. And again, this sometimes sounds like easier said than done. There's many different types of IP, and even within the different types, like patents, copyrights, trademarks, and trade secrets, many times people don't fully understand what is it that's protectable by patents in the game context, right? What can I copyright, etc. So the thing that makes games interesting from an IP perspective is that there's both interactive or functional aspects of what the game does, the game mechanics, etc., and then the creative artistic aspects. And both types are protectable. So when you start to try to figure out what do you have that's protectable and assess it, from a patent perspective, you want to focus on what does the game do, what's the interactivity, the game mechanics, the overall processes that you're using, any hardware elements, UI features. There's a whole range of different types of things that are kind of on the functional or process side that can be protected by patent. On the copyright side, you're going to protect primarily the look and feel, the GUIs, and the actual code itself can be protected by copyright. Now, many people ask, what's better, patents or copyrights? And I say, well, that's the wrong question to ask. What you really want to do is protect both. You really want to have comprehensive protection. And lastly, trademarks are important too. Not just obviously the name of the game you may want to trademark, but if there's characters or other items in the game that might be separately monetizable, you want to try to get trademark protection for those as well. Okay, so from a protection perspective, as I started to say, it's important to develop a comprehensive IP strategy. In my mind, it's not a good question to ask what's better, patents or copyrights. They cover different things. If someone takes your core game mechanic but changes the look and feel, copyright protection is not going to help you. Patents will. If someone copies the look and feel but changes the mechanic, then copyright might protect you more than patents. And trademarks, again, is kind of in a separate category. But patents and copyrights are not mutually exclusive by any means. Patents do provide probably the strongest form of protection for game mechanics and gameplay and processes and those types of things. They're more expensive, and you actually have to file for patent protection and actually get the patent awarded. Be mindful that there's a 1-year time period. From the time you disclose something or commercialize it or publish it, you have 1 year to file a patent or less. The or less is if someone files before you do, you lose out. It used to be that whoever invented something first got a patent in the US. Now it's whoever files first. We went to a first to file system a couple of years ago. Copyright's nice thing about it is that you get copyright protection from the time you create a work. From the time it's, the statute says from the time it's fixed in a tangible medium. So you store it on a disk, boom, you have copyright protection. You don't have to file to get copyright protection. But there's two critical things that you get by filing copyrights. It's a federal copyright registration. It's $35 to file online. You can do most of them yourself. But what happens is that if you timely file, you can get attorney's fees and statutory damages. So why are those important? Generally, if you want to file a copyright infringement lawsuit, you have to file a copyright at some point. You don't have to do it right away. You don't have to do it right when you publish the work. But before you go into court, you need a copyright registration. So you can do it anytime. So I do it earlier. Attorney's fees. Normally, most copyright infringement, particularly with respect to casual games and things where there's not huge dollar volumes, the cost of having an attorney do a lawsuit for you is going to be more than the money you're going to get, particularly if you catch the infringement early. And it's a tough business decision to say, I'm going to spend X dollars to get Y back, right? You set a principle, you protect your IP, but there's a cost to it. With if you file copyright protection timely, which is right around publication, you can get attorney's fees awarded. So that can be a real significant advantage. And the second thing is you can get what's called statutory damages. But without the benefit of timely copyright protection, you have to prove what your actual damages are. And that gets kind of difficult. If someone is out there in the market and they're not selling a lot of games or they're giving the game away for free, showing what your damages are, your loss, not their profits, but your loss, can be a difficult thing. And it's expensive. You need to get a damage expert and you have to go through all that process, etc. With statutory damages, a court can award, if there's infringement, more like punitive damages. They can award up to $150,000 per infringement as an award to you without you proving your actual losses necessarily. So those can be very powerful tools, and because it's so cheap and easy to get copyright protection, we strongly advise that you do it. Not everyone does. Trademarks. Again, like copyrights to a certain extent, trademarks, you get protection in trademarks from the time you use it in commerce. So if you publish a game or start doing something commercially with a trademark on your game or in your game, you have some protection. If you file a federal trademark registration, you get some additional benefits as well. And the other thing that's important is that you can file what's called an intent to use trademark application. And intent to use is if you have a bona fide intent to use a name. So you're in the process of developing a game, you've picked a name for it, you develop some characters, you have some names for your characters, you want to protect it. You don't have to wait until you actually use it. You can file a trademark registration, say, I intend to use this, and then you'll get it examined. And in order to get the trademark registered, you'll have to actually start using it. But you at least get the benefit of having the earlier date compared to someone else who may come along after you. The last thing I want to say is repeat. The important thing to think about with IP is that it's not a set it and forget it type of thing. It's not something you do once and say, okay, I filed my IP, I'm good. You're going to constantly iterate on your game. You're going to make enhancements to it. You're going to maybe change the business model. You may adopt new logos or different kind of look and feel. There's all different aspects of your game development that's going to change and require a reassessment of, is there any new IP I should be filing? There's no set time to do it. Many companies will do it quarterly or at least every 6 months. Sometimes you'll do it timed with each new major release. Or if you port to a new platform or different events like that. There's no real set rule other than just do it. Make sure you schedule it. Make it part of your development release process. It's important. Just to give you a sense, people kind of question patents, and are people still filing patents? Here's a chart that shows over the last 30 years or so the number of patents that have been granted in the U.S. And you can see that Back in '76, it was about 50,000 a year, and the last 2 years we're right around 300,000. So a six-fold increase in that time period. And you can see particularly from about 2009 on, there's an exponential rise in the number of patents. And if you overlay that on top of the number of patent litigations, you can see from this slide the number of lawsuits filed, it too has risen as more patents are issued. One other advantage of patents is a defensive value, and that is because, as I mentioned earlier, there's this first to file system. If you file a patent on something you're doing, no one else can file that patent. If someone else independently develops an idea similar to yours and files a patent before you, then they can get the patent, and that could potentially block you from doing what you're working on or what you want to do. And so the defensive value of a patent to prevent the opportunity for someone to file a lawsuit against you can be a huge savings. The average cost of defending a patent litigation, generally in the U.S., generally between $1 and $3 million. And as a defendant, if you lose, even if you win, rather, you're out that money. There's no upside. Generally, attorney's fees are not awarded. So you could pay that much just to get out of to defend yourself against the lawsuit. So for all of these reasons, both offensive and defensive aspects of IP, it's important to protect what you're doing. We all know there's a lot of game copying out there, and some of that's going to exist, but a lot of it exists because companies don't take the time and effort to protect what they're doing. Don't be in that category. One of the things, we do a lot of work with investors, and different investors care more about IP. Some will care a lot, some won't care a lot at all. But I can tell you, for the ones who care, having solid IP protection for your game can be critical. Well, those were the comments. If you want, we have a white paper that kind of goes into some of this a little bit more on IP protection for games. Would love to send you a free copy. If you just shoot me an email, I'll get that over to you. That was pretty much it. Try to keep it short, simple, and concise here. The key thing is work with an attorney who knows what they're doing in the game space. It's different than biotech patents, obviously, and so we do a lot of patent and other IP protection for games here, and we'd be happy to talk to you.
Awesome. Well, thanks so much, Jim. That was wonderful, very concise and to the point. So I'm sort of putting myself in the shoes of a couple of guys who are just getting started and starting their game startup and thinking, wow, that's a lot. What is important for me to do now versus what's important for me to do 6 months into this, when I actually maybe start getting some revenues and actually have something to show for it. So do you have a recommendation that, based on stage of startup, success of the games, and profitability, what is necessary from an IP protection standpoint?
Sure, it's a great question. And the short answer is, like most legal answers, is depends on a number of different factors. Each situation is different. But putting the legal jargon aside, the thing I strongly suggest is, once you've got a concept, once you're kind of going in a direction and you've got something sufficiently formulated, it's a good time to sit down and have an initial conversation with an attorney to at least understand, what do you have that's potentially protectable, and what's it going to cost, and how we do some we have flexibility with startups sometimes on timing of payment and certain things. We want a fixed discounted fee and things like that. But at least understand what you can potentially do, understand what it's going to cost, figure out what your resources are, and then, like any other business decision, allocate those resources. And in some cases, it may mean, let's go ahead and file a patent early. In other cases, you may say, okay, well, let's wait and see what the market looks like, and if people really like the game and they're spending money on it. The trade-off there is, if you wait, as I said, if someone else is working on a similar game and then they file a patent before you, that waiting may cost you. So, there's a little bit of, uncertainty there, and it's a race to the patent office to a certain extent with respect to patents. But again, it's like any other business decision. I mean, you have to take into account all the facts, but without knowing the facts of what you can protect and how meaningful that might be, it's hard to make an informed business decision.
Got it. So I wanted to quickly touch on two other topics that you mentioned, because it's come up in my conversations with a lot of game studios over the past few weeks. So the first was, you mentioned, what are the rights that people are giving away to publishers? And I've seen things such as right of first refusal and global exclusivity being such that basically a studio was unable to get further follow-on investment because it basically locked out any strategic value for a future investor into that game studio. So even though the game was doing well, and actually had great metrics, that studio was unable to get more money in order to keep going. So was there anything around that you maybe wanted to add beyond what you have in your slides?
Yeah, each negotiation is different depending on the size of the publisher and where can they bring value. I mean, giving a global to any one publisher is generally a bit risky. I mean, not everyone can market to the whole world. I mean, you may have different partnerships in different parts of the world. The China market is very different than the U.S. market versus the European market, and so you want to think through that. But one of the key things with respect to granting rights, particularly exclusive rights, is you typically want to have performance metrics or something that doesn't tie you up forever. So either the publisher is spending money and working towards certain milestones, and if they don't hit those milestones, you typically can do one of two things, or there's a couple of different things, but the most common are they have to make minimum payments to keep that exclusivity. So whether they're generating enough royalties to meet the minimums or not, they can top it up. And if you're getting a certain amount of money, it's better to get your game out there and have it be productive. So that's one option, is just take a minimum payment in those jurisdictions for them to maintain exclusivity. And the other is, and it's more extreme, is if they don't hit certain milestones, the exclusivity goes away. And you can either take it over yourself, find a new publisher, or cut a new deal, or do whatever the ramifications you want. But at least you don't put yourself in a position where you're boxed in. And same thing with marketing across different platforms. I mean, sometimes we'll see, and sometimes we see that with developers too, is that someone's developing for a mobile platform and they want exclusive rights for any other platform. Well, if they're not geared to do VR or whatever, I mean, you may box yourself in a situation you don't want to be in. So you want to really think through it. Look, I mean, at the end of the day, developer relationships, if you're using an outside developer, and publishing relationships are business relationships, and you want them to work, you want there to be upside for each entity. But there needs to be protection so that you can't be in a situation, whether it's intentional or unintentional, that you just can't maximize your opportunities because they don't have the right resources or knowledge or whatever it is that prevent, or even just the interest. They may be stretched too thin. And even though they could do it, if they allocated the resources, you got a good game, but they work on another game that's a great game. And so, of course, they're going to go where there's more money. So you have to just factor all of this into your agreements up front and make sure that you're fair to your business partners, give them some upside, give them incentive to really maximize what they're doing for you, but do it in a way that you don't get put into a box.
Right. Very, very good points. I think the other thing that happened with that particular studio was they also had a right of first refusal, which you also mentioned in your presentation. Yeah. And as a result, that particular publishing company just took a long time to get back to them with whether or not they're exercising the rights, and no one else wanted to take a meeting with them in the meantime, because why go there if someone else already has a right of first refusal?
Right. So just to expand on that, so the right of first refusal, it doesn't necessarily give someone a right to do it. It just says that if you're going to grant rights to somebody, they get an opportunity to cut a deal with you. The problem with that is, others, if they know there's a right of first refusal, you do a deal with them, you say, like, well, if we cut the best deal we can, but I have to go check with the other guys, see if they want to match it. Who's going to want to spend the time, effort, money to go through that negotiation if it can be pulled away from them if someone else steps in? And so that's where the practical problem comes in with right of first refusal. So, generally, if you're going to do a right of first refusal, you want to structure it in a way where you don't get in this procedural bind. So, for example, if you wanted to port to a new platform, you could say, we'll go to our publisher, and you can make an offer to us, and we can either take it or not take it, or you can put certain parameters in it, and you can have a very limited period of negotiation. And if you don't reach an acceptable deal, then that you go past the right of first refusal, and you're free to negotiate with other parties. There's different iterations on how you do that, but again, if you do a right of first refusal, you want to do it in a way that's not going to present that practical problem that no one else is going to want to negotiate with you.
Yeah, this is what I love about you as an attorney, Jim. You not only share what is protectable and go the litigation route if need be, but you also set the tone from the get-go for one that avoids litigation. So I really appreciate that about you over the years we've worked with you, and love that we can actually share that now live with our audience of YetiZen Speaks Online.
My pleasure. Thank you. We try to take a practical business approach, and that at the end of the day, that usually is the best approach, and everything else on the legal side is a fallback, and it's more of a protection. But you really need to develop good business relationships and develop good business agreements to succeed.
Awesome. Well, thanks so much for your time today, James, and we hope to see you very soon at the next YetiZen Speaks Online.
Thank you very much. I enjoyed it.
Likewise.
Thanks,
Take
everybody.
care. Bye.